have any, and we're continuing testimony 409, and we're going to hear from the Department of State's Attorneys and Sheriffs. Over to you, Kim.
Good morning, everyone. For the record, my name is Kim McManus with the Department of State's Attorneys and Sheriffs. Thank you for having us in for House Bill number 409. First, we just want to acknowledge and appreciate this committee's work on trying to tackle this issue of repeat offenders, to try and wrap our hands around what is possible. And we know that you did a tremendous amount of work last year on Act 138. And again, we just want to thank you for that. And we want to acknowledge that in last year's work, we think you've really appreciated the corrosive effect of repeated violations of conditions of release, what that does to our system, what it does to our witnesses and victims, and then to our prosecutors and our defendants and defense attorneys. So we just wanted to acknowledge that, and we really appreciate this effort to continue that work, to try and, again, figure out where can we make certain changes to maybe be able to address some of these repeat offender situations. We absolutely understand that there is a constitutional presumptive right to bail in Vermont. And without any change to our Constitution, we have a very narrow path that we can walk here. But the legislature and our Supreme Court have found that there are legitimate and compelling state interests that would support revoking bail in very limited circumstances. As the case in Suave, which you heard about yesterday and a little bit today, held that revocation of conditions of release is allowable under the Vermont Constitution if the grounds for revocation were based on a compelling and legitimate state interest. It is very important to note that Suave found that subsection 1 and 3 of A are constitutional. That has been found. It is also important to note that Suave and Gates later affirmed that subsection 2 is constitutional if the revocation is due to repeated conditions of release and there is shown to be a nexus, a connection to that disruption of prosecution. As you heard earlier, and I will affirm, prosecutors do find 7575 very frustrating in general. It's very difficult to bring these forward. It often feels like a last resort, a Hail Mary pass, if you will, when we feel like we have nothing else to do, but we feel like we're being irresponsible if we don't try to use this mechanism. And as noted earlier, we almost never use subsection, I want to make sure I keep saying this wrong, A2. Excuse me one moment. Too many papers in front of me. Oh, here we go. Yes, subsection A2, because we don't know for two reasons. One, we're unclear on what disruption to the prosecution means. And we also have found that in trial court orders, that there's sometimes a conflation of the of the requirement in A3, which notes that someone has violated a condition or conditions of release that constitute a threat to the integrity of the judicial system. Many of our prosecutors, when they do try to bring these cases forward, often feel that there's an additional layer put on to the decision that again, that this threat to the integrity of the judicial system is an additional hurdle that we have to meet. And we would argue that this legislature laid out these five reasons to revoke as finding those as inherently threatening the integrity of our system. So that's just one thing to note as we move forward. We in no way seek to lower the bar to revoke a person's bail. But we do wish to clarify what the bar is and how we, the state, can meet that standard to revoke by a preponderance of evidence. We really appreciate that this bill is beginning to work on that and to try and bring some clarity to subsection A2. And again, we believe there is a path forward and it is quite narrow and we need to walk it carefully, but we do think it's viable and constitutional. One thing I will note.
Before I just want to clarify the argument is on that that the legislature in, I'll specifically look at A2, it's inherent that behavior, the impeding or disrupting, impeding the prosecution threatens the integrity of the judicial system. Is that what I understand?
I'm sorry, could you just repeat that?
So are you saying that maybe you said for all of these other than three, that it's inherently threatening the integrity, that the legislature essentially, that it's inherent that A2 threatens the integrity of the judicial system?
That is what we are finding on the ground, is that we are being asked to prove that in addition.
So the court is saying you need to prove that for 1, 2, 4, 5, not just 3. 3 is where it's explicit. And you're saying that, well, the legislature must have actually meant that it would inherently impact the integrity of the judicial system. Or you're not saying that second thing? Well,
no, and actually, I'm glad you said that, because I want to restate what I said, because as you said it out loud, it didn't make sense in to me. But those were my.
I may not be making sense.
No. But so the legislature, when it laid out these 5 moments in time when they said, you know what, this is too much and revocation is appropriate. When deciding that, I believe, coming off of Schwab, said essentially these are legitimate and compelling. This reaches legitimate and compelling state interest, right? If somebody's intimidating or harassing a victim, you are now pushing against that limit there. We think you have then gone past. And so we can now revoke. What we are finding on the ground, and one is a good example because that's actually the one that I think gets used the most. And the one that we do have some success sometime. I don't want to say it never happens, it does. Some success in one, but often the decisions will say, yes, we find that the state proved that the victim was intimidated or harassed, and it threatened the integrity of the judicial system. And we would just push back that we're not sure that's necessarily, that we don't think we necessarily need to have that additional piece there, that's inherent in, if you are intimidating and harassing a victim, right? It's implicit that that's threatening the integrity of the judicial system. So it's something I raised because it to our practitioners, if they're being told, and again, this is a case-by-case basis, but enough that we always have to show that there's a risk or threat to the integrity of the judicial system, then we believe, okay, now we have to layer that on to number 2, right? The disruption of the prosecution. So it's one thing to disrupt the prosecution, and what we want to talk about today is how do we define that and maybe help make this tool a little bit more clear so that prosecutors could use it in the future. But if that comes with, again, this implicit, and not only do you have to show this disruption to the prosecution, you've disrupted this case, you have to show that it threatens the integrity of the judicial system. That's another bar. And so we just wanted to highlight that this is an issue happening.
So, not to get into case law too much, but I can't help myself. But looking at the main case, State v. Schwab, where and this is something that Tucker already quoted from, that such flagrant disregard of conditions may show disrespect for the judicial system, but these violations do not necessarily threaten the integrity of the judicial system in the constitutionally limited sense that they thwart the prosecution of the defendant. So it seems like if you thwart the prosecution of the defendant, you are necessarily threatening the integrity of the judicial system, is what it says. So it seems to me that all you have to show is that you're thwarting the prosecution of the defendant, at least the way one should be reading, I think, SWAB. Though I'm not a Supreme Court justice. But my question then is, all right, putting that all aside, impeding the prosecution of the accused, changing that to disrupts, I don't see how that frankly changes that much, except that's a word that's used elsewhere. It's a matter of how you define it. But the Supreme Court seems to be saying thwart, and thwart is not the same as impede, or is it?
Good question.
If we just change that word to thwart and define what we mean by that.
So I do want to be careful and on the fly. So one of the issues in SWAB is when discussing the thwarting of the, I don't believe, and I'd have to look, I don't believe they're talking about subsection 2. I think, again, they're talking about subsection 3.
And they're referring back essentially to subsection 2, but they're saying thwart and not impede.
And again, it would be, and again, it is so important to be having this conversation because this confusion is what we have on the ground.
Okay.
And I think, so again, our confusion is, what do we need to bring? Basically, like, how bad does it need to be before we can revoke someone's bail? And we do think the language change from, just, if you don't mind, I'll go. We do think it's important to change impede to disrupt, because what Gates followed up with SWAB, it specifically used disrupt the prosecution. So yes, I was looking up the definitions last night. Very little. There's a difference between impede and disrupt. It's small. But if the Supreme Court has used disrupt the prosecution, then we do believe that the statute should align with that. We also believe that it makes clear, that the nexus that Gates and SWAB speaks about, that's clear then into that there's essentially 2 elements that the state needs to show. 1, that there's repeated conditions of release, and 2, that these repeated conditions of release are disrupting the prosecution. So we believe that that is important, that
violations of.
Yes,
Okay.
violations of conditions of release, and that those violations disrupt the prosecution.
Yeah, go ahead.
Oh, okay, I'll ask this question and admit that I'm not sure if it's the right time to ask the question. But I thought that what I was hearing earlier, I think when Tucker was speaking, and maybe this is what you were saying earlier as well, that in this number 2, I'll focus on disrupts it. Well, yeah, so disrupts the prosecution of the accused. That's clear to me what that's referring to. It doesn't say disrupts the integrity of the judicial system.
Correct.
But you're saying, or what I feel like I'm hearing or coming to understand is that is being used as, is it that it's being interpreted that way, or that the argument is being made that repeated violations disrupt or that repeated violations constitute a threat to the integrity of the judicial system? Is that an argument that you're making as well?
So what we're finding, and again, number 1 is an easier one because this is one that we have a number of examples of. Number one doesn't mention anything about threat to the integrity of the judicial system, right? It just says intimidated or harass a victim, potential witness, juror, or judicial officer in violation of condition of release. When you look at decisions around number one, the court will add, we found this harassment and the harassment essentially reached this level that it is threatening the integrity of the judicial system and then therefore revokes. So sort of it's sort of adding you have to reach this level. And we on the ground don't know where that level is. And I understand it's a constitutional issue. It says it in one of the cases, but we don't know what it is. And we've been given a few examples like destruction of evidence, right, is mentioned in one of the cases. But what else it is unclear.
I think, and I hear that part and that's helpful. And I think my question is a little different. Like, I think I'm wondering if we're being asked, if this committee is being asked to almost to either understand or assume that repeatedly violating conditions of release is a threat to the integrity of the judicial system.
So again, I think we have to be careful. It's again a really narrow path that we can walk. And I don't know how far you can say that. What I believe you can say is that, again, this list that was made was because the legislature found that this reached the level of legitimate and compelling state interest, right? That then allows to push up against that constitutional right? That you need to reach that. And that number two was one of the reasons that back again, not you all, but your predecessors, I believe in 1992, 93, said, if these repeated violations of conditions for release are then impeding, now disrupting the prosecution, that is that legitimate and compelling state interest. We want to keep that. We're not advocating that you add a layer of needing to also show that it threatens the larger integrity of the judicial system.
Okay. I think that was my question.
Okay.
Yes.
No, we're not advocating for
That would
that.
be a huge change.
No. If anything, we want to clarify, and again, it may not be for this body to do that we don't need to show that for subsection 2.
Yes.
And depending on how that definition of disrupt prosecution, how we work on that, we think that could help.
Okay, thank you.
Tom.
How often does folks are working on a plea agreement or some kind of case resolution, and you just about have it wrapped up in your wait for your next hearing to do it, and you find out the defendant has reoffended, or before you get there, boom, they've been arrested, and it can't really be added to what you have. Is that a common thing where it just causes the can to get kicked down the road again?
Yes, and it would, and that would, when we get to possible suggestions for disrupting the prosecution, that is one place that we think we could suggest a very tangible example of disrupting the prosecution, that the underlying case has to be continually delayed and delayed and delayed, because understandably, the defendant would ideally like to deal with all their cases globally. And when a new case pops up, they say, oh, wait a minute, we need to now look into this. We don't want to start with the underlying one because we don't want to pick at this piecemeal because it doesn't serve the defendant, understandably. But yes, then it's a 30-day continuance, a 60-day continuance. So that, and one of the examples I'll present in a moment, there's a misdemeanor case with a 2-year, it's been ongoing for 2 years with 25 violations of conditions of release. So yes, that one could argue that that original case has been barred from prosecution due to those repeated violations of conditions of release, that it keeps getting pushed out. So,
Yeah, that could also jeopardize their ability to be, or attend some programming or something like that, the new case correct. So that would restructure the whole sentence.
potentially could change the if they were at the point of an agreement, it could change the agreement. Often we can't even, depending on how many offenses are occurring and if there's crimes and BCRs together. But yes, that would definitely continue things.
And I haven't seen this whole bill. I wasn't here yesterday, obviously, but it said revocation of the right to bail. I mean, does it seem to you that and maybe it's covered in here, but does it seem to you that someone could have a reasonable bail placed first? Is that what it means, revoking that bail? If they've made it, or if they're out on pretrial release without any bail, going straight to bail revocation sounds a little bit extreme. Maybe.
Correct. And then, right. And so any of the other bail arguments could occur as far as wanting to place a higher bail at the arraignment on that new VCR. That would be those bail arguments. And there's some suggestions later of maybe some language in other sections of the bail statute around that may or may not help.
So I think for today, we're going to ignore all the procedure stuff.
Okay.
And we're just going to really focus on that definition. Because if we can, that seems to be where there could be the most help. And I guess there's two questions that I'm going to have, and just a time check that we don't have a ton more time on this. One question is why can't, and I know you're ready to address this one, why can't this be resolved just through the motion practice under the existing law right now? Why can't the state's attorney push this issue in requesting bail revocation based on facts like the 25 repeat offenders and the like? And then also I'd like to have your input on what is that narrow definition of disrupt, impede, thwart, if you pick? Because what matters is what we put in the definition. So those are two questions. You could address those in 10 minutes or less.
Sure.
And then I'll give Judge Zoni 5 minutes. 3 will work. Okay.
Probably give Judge Zone a few of those minutes, possibly. So for your first question, I just want to make sure I heard it correctly. Were you asking what is preventing us from making these motions?
Well, why? I mean, goes back to Ian's question originally, that it's like, why do we need to solve this? Why can't this just go through a motion based on the facts that you want us to put in here as far as defining what thwart means? I'm sorry.
I didn't raise swords.
Yeah, that's like, I'm stuck on that word. So two separate but interconnected issues there. And one that this body very much could address. The first one, the ability for the state to appeal revocation decisions is slightly murky territory. In that it's very clear that a defendant can appeal a revocation order under 7556 A and B. The defendant is detained. They have a right to have their their detention reviewed by a single justice, and that single justice can decide that needs to be referred to the whole court. The ability for the state to appeal is in 7556C, and again, it's slightly unclear. We're able to appeal decisions. I'll just pull up the language. 13 DSA?
Yes, sorry, I apologize. 137556. In C, it says when a person is released with or without bail or other conditions of release, an appeal may be taken by the state. So what gets a little tricky is if somebody has already been on release, right? And we motion to revoke, but the revocation doesn't happen. Are they sort of being released again, or no, they're just continuing their release. So we can always appeal that initial decision. Not a motion to revoke, but if we make a bail argument, and somebody, whatever the conditions of release or bail amount are, we disagree with that, we can appeal that decision. That's clear in 7556C. It's a little unclear whether we can appeal a revocation. Now, I was able to find, when you look through, not surprisingly then, decisions, it's almost always the defendant appealing the revocation because they've been detained for a certain amount of time. There is a case, State v. Knight, and the state appealed that decision, but the motion to revoke was coupled with a new arraignment, a new charge, and the court deciding not to bail the person. So it's very good. So even though the court did make a ruling on whether it could be revoked, the court in that case didn't say, we're doing this under the authority of, it was just sort of coupled with this bail review. So we just highlight that we're a little unclear, and that we would absolutely appreciate if either in 7575 in this revocation section, there is clear language about the ability for the state or the defendant to appeal, or that language could be cleared up in 7556, just to make it abundantly clear. Now, with all of that said, I'm going to talk as fast as I can.
Oh, no, it's all right.
We also have a resource issue on our end. We have one appellate defender. And as you have heard repeatedly, our average caseload is 400 cases. So the ability for Deputy State's Attorney to file an appeal, we do it. We don't always have time to do it, depending on what our other cases are going on. So just something to flag. And these bail reviews, they come up quicker than a full appeal.
So, yeah, no, I guess I understand, but
So I can answer to your second point, what would any language changes do?
yeah, but before even that, it's like, is there language that we could get? So I would imagine we would be in a better position if we want to move on something quick or in the miscellaneous bill. I don't think, maybe I'm wrong. Would it be that controversial for us to make it clear that the denial of a bail revocation is appealable? That would seem to be one approach. And then the court is ultimately going to have to sort this out, whatever we do here. So if we can already initially establish that path where even without us doing anything more than that there's at least a path for the correct case for Evan to take up, I guess, that at least would be some near-term help, even though that process takes a while. So in any event, that's something we can look at, but go on to the next question. Sorry,
Well,
I won't count that minute against you.
Yes, exactly. I'll take it.
Yeah, Ian, go ahead.
Just very briefly, so has there been a bail revocation appeal that was denied because of the lack of clarity in 7556?
I don't believe so.
Okay.
And so no, and I absolutely don't want,
Okay.
I do not believe so.
But you think that the lack of clarity in 7556 is preventing some, besides the resource issue, I understand that, but that lack of clarity is also preventing prosecutors from appealing?
We believe so. And again, I think it's part of this friction and frustration that 7575 is this hurdle that is so hard. And again, real or perceived, this is how it's felt on the ground. It's so hard to overcome. And so then it's like, oh, now I'm gonna try and appeal it. I think there's and then if you read the statute quickly as a average deputy state's attorney, like, I'm not even sure if I can do this.
Yeah.
And then you're moving on to your next thing. So it's not to say that we can't. And again, and I will keep looking, but I was trying to find entry orders where an appeal and that we were the ones who appealed it, and I've only found the one so far.
Yeah.
And quickly, I checked in with our appellate attorney, and when he says he said this is a little unclear. And that's usually good enough for me. Now, so with that said, one, yes, if that language was clear about our ability to appeal, I think that would be incredibly helpful. But two, this language around disruptive prosecution, we do feel there's great value in this body. It essentially signals to the public and to us that this matters, that this is an issue that should be brought up in court, that should be argued. And to your point, it needs to be argued and then brought up to the Supreme Court for their ultimate decision on it, and to give us feedback on that. But we do think that by changing the word to disrupt and working on this definition of disruptive prosecution, that does give us an opportunity to do that.
How about the language that we have in here for disrupts the prosecution? It seems problematic to me. It
Yes.
seems to be much broader than the narrow path that we're seeking. And do you have any language that you would suggest? I'm not asking you to read it to me now, but you have language that you could provide that we could consider this afternoon or tomorrow? Because
We would
still.
be happy to submit some suggested language. Representative Oliver was raising one piece that we think, again, might be a tangible example of disruption of prosecution where the underlying case has had to be continued for X amount of time, and that X is up to you all because of, right, the violations of conditions of release are causing that. Maybe that's one possibility. Well, but right, so that's important, right? So what is the nexus? What's disrupting my ability to bring that case? If the underlying case is that, oh, we're scheduled for next week. This case has been ongoing for 90 days. I'm ready to do my misdemeanor trial. The week before, you, defendant, violate conditions of release by contacting the witness. Oh, you also criminally threatened the witness of the underlying case. Oh, now I have a criminal threatening charge to arraign you on and a violation of conditions of release.
And a very clear way to get revocation of bail. In that scenario you gave me, give me a different.
That's a very clear one, right?
Is it?
How about a different scenario? You've got,
Well-
you're 2 weeks out from a hearing and there's a completely unrelated violation of conditions of release.
Well, they commit another crime, they
They commit another
trespass again.
So that does delay the hearing. How does that have any nexus?
Well, if it delays the underlying original case, right, isn't it disrupting my ability to prosecute?
And
If
this
it's
is-
continued again and again
This is
and
helpful to
again.
clarify. So I'm understanding the nexus to be the nexus of the violation needs to be related to.
No, the violation is disrupting the prosecution.
Yeah, and what that violation is, I thought was what had to be. And maybe I'm misunderstanding.
Well, I mean, whatever it is it disrupting or impeding or thwarting prosecution? So before we continue, this is next half hour, and so
Yes.
I will instead await some suggested language from you. It seems like a long shot that anything's going to get passed by tomorrow, but it is going to be an ongoing conversation. And I do think if we could have some language on the appeal as well, and we'll hear witnesses, and if that is not controversial, I don't know if it is or not, then at least I could see that going into the miscellaneous bill when we get that over. So, all right, so we're gonna move to Judge Zone. Thank you very much, and I apologize, but I think
Not at all.
we need.
I think I'll say for 20 seconds, just for the record. And we do wish for you to focus on this definition, and we're happy if you take everything else out just to do that definition. But obviously you have a lot of points on the procedural stuff. if that happens to
Yeah, if we're gonna,
Or in the
if it's gonna keep
future.
on going,
Yeah.
we'll have you come back and on the.
very interested in working with you on that. piece.
Yeah.
Thank you.
Thank you, Kim. Thank you for your flexibility. Well, thank you. All right, Judge Zone, thank you for being here, and I'll assume that you've been patient.
It's here all morning. Tom Zone, Chief Superior Judge. So where do you want me to start?
Let's start with 409, and we are not getting into procedures, and you can tell us that it's policy, and we'll move on to two. But if you have more,
I think that when the evidence, with the testimony you've heard yesterday was can't do it. Testimony you've heard today is from others you can do it. I think that that is probably the clearest indication that you're not going to hear from me one way or the other. Because what I think we can all agree on in this room and those who testified yesterday is whatever statutory changes are made are going to be addressed, decided, and litigated in the courts. And I have to, as you know, I can't get into any advisory opinions. And I think these types of issues are ones that if I say anything about, well, it looks like this, it could look like I'm giving comment. I can't do that.
no, I absolutely understood that. I'll ask a question, see if you can answer it, and that is this concept of appeals. And is there any immediate red flag if we were going to try to change the law to make it clear that one could appeal a denial of a revocation? Because that would presumably be an interlocutory appeal, but can the legislature weigh in and say, no, you get to appeal?
The legislature established the right of the state's attorney to appeal bail decisions under 13 VSA 7556 subsection C. The legislature decided that any 75 appeals would also go there to provide the clarity that has been indicated is not there by the state. Legislature can certainly add that.
Okay, all right. Karen and Angela. And Barbara, I didn't see you.
I'm not sure if you'll be able to answer this or not, but I'm wondering, not so much the details of how this happened, but would you agree that there is a problem that we're trying to solve here? Or, because I feel like what the other thing I've heard is that there are tools that exist already. And so is it working on those tools or do we need to solve a different problem?
The courts address the cases and the facts and the law that comes before them. The application of the law by the judges in the individual cases sometimes will have people in the public saying, we agree with this, so we think it's great, it works wonderfully. And on the other side, people say, we don't think it's working well. So it's not appropriate for me to characterize how people may feel. All I can say is that when the cases come before the courts, we do our best to make sure that we follow through with what George Washington said in 1789, that is, the due administration of justice is the firmest pillar of good government. And we apply the law as we need to.
Angela, you want to take a shot and get the?
Yeah. It's probably the same question.
Okay.
Trying to rephrase it.
I gave an initial try.
Barbara, and quick question.
So nobody talked about the standard of proof at all, and I'm wondering if in 2A.
We're not dealing with any of that procedure part
Okay,
yet.
never mind.
So that'll be future testimony. That'll be future testimony. Yeah.
Okay.
Very, I just have,
Go for it. Go
very
for it.
brief. I just want to know,
Yeah, no, go for it.
who should we ask if I wanted to read a trial court decision on a denial of a revocation of bail motion under subsection 2?
Me.
Is that something that we could see? We could see one of those?
Do you have a specific case that you're aware of that a judge did
I
that?
have some
If you do,
On 2?
On 2, I'm not sure. I'd have to double check.
Okay.
if you know the specific case, I can get a copy for you as long as the case has not been sealed or
yeah.
expunged, but
But I would
I
need
can
to
get a
know-
copy.
I would need to know the case though. Okay.
All right. So are we,
I think
Tom?
Rule 3. I love Rule 3. You did a lot. And we're using a lot of time up now, reprocessing individuals as police officers before they go to court. And then the court does whatever they do, and then we do it again. So we're spending a lot more time with the individuals over and over. And Rule 3 seems to have a very clear intent to me, and that's to stop bad behavior. Does it align with our current bail statutes? Or do we need to work on redoing it?
What aspect?
Well,
Rule 3 for the
Right.
committee, Rule 3 is a rule of criminal procedure that provides the mechanism for law enforcement to arrest someone. For instance, it sets forth that law enforcement would not need to have a warrant for someone for a felony. It then says that if there are certain misdemeanors, and it lists them, the officer may arrest without a warrant for unwitnessed misdemeanors. And then it also talks about the other procedures. So I don't really know that.
Okay, well, so I guess I'm alluding to going down, like, arrest is necessary to prevent the continuation of criminal conduct for which a person is detained, or to prevent harm to a person detained or another person. So suppose they do something.
If I think I understand your question correctly, the way that aligns with the bail is because that is the commencement of the proceeding. That's the commencement of the case, if you will. The officer would arrest a person. If they take them into custody under one of the limited exceptions there, then what would happen is the officer would have to contact the judge, and the judge would make the decision. We then have Rule 5, which talks about after hours and the bail decisions. That as an officer, you know that what happens is you'll call the judge and say, here's what we have, what conditions are any bail. And so the Rule 3 is before the bail decision, and it's what takes the officer to ask the judge for the
Right.
bail issue.
But that brings me to my next question, is many times we do this and we don't even get to the judicial part, and they say release on a citation. We don't have time for it. So in an effort to save time, shouldn't we just be citing people? Or is arresting people, or do we need to evolve we go to Rule 3 as a police officer, we're taught to go to Rule 3 to try to stop the behavior so that there's an intervention. And maybe if that intervention, a lot of judges will, you have been before me 3 times this week. I think it's time you have a cool off period, and then we'll get you back here once, you're clean and sober and think through this again and maybe try conditions of release.
Rule 3 provides an officer with, as you know, with discretion. And the officer, when they exercise that discretion, if they take someone into court, if they take someone into custody, the officer would generally then contact the state's attorney, and then the state's attorney has discretion to determine how they are going to go forward with the case. And then when the case is brought before the judge has to follow the statutes and rules, and the judge has discretion in applying the bail law. So at each step there, the courts, at each step, there is discretion being exercised. And there's no one size fits all model, because every individual in every case and every circumstance is different. So it's individualized.
So bail is like a continuum.
Well, there's no one size fits all.
Right.
But we don't have, some states actually have, if you commit or are alleged to have committed crime X, your bail is Y. We don't have that in Vermont. Bail has to be looked at on the specific facts of the case for the individual.
Good.
I'm good.
So we're going to move to H222, and we'll start with Judge Zorro, since we had the chair, and I think I actually technically done it first, but maybe I didn't. Yeah, I did. That just worked out well.
No objections to the bill. I did see the change about taking out the language about it was at no cost to the defendant. That I know was added because of the fact that I recall early on in the process, that was quite important about whether or not individuals would be able to afford it. And it certainly, that's a policy decision.
And presumably it is no cost until we run out of money. And that's why I was a little concerned about saying at no cost, because the way things are, I'm a little concerned that money might run out for that.
And I know there was a question about having a different type of response, that it's not criminalized like the others. But I think it's also important to keep in mind that this is a different type of section, order. Generally, what do the orders say? You shall not, you shall not. This is something that has an affirmative obligation for someone. And having that carved out provides also the ability to align better with the statutes on 665A that deal with parental rights and responsibilities, because in the domestic docket, there is a provision that says judges can order these types of programs. And so in that docket, if someone didn't do it, they'd be subject to the civil contempt. So you're really aligning things there also and not having inconsistencies. And generally, the cases are consolidated. So you're giving one remedy, if you will, to that type of issue. But that, again, that's a policy decision.
Appreciate it. Questions for Judge Zone on H222? Go ahead, Angela.
I appreciate that it is a policy decision and policies have impact on the court, you know, and so that's why your counsel is so valuable. As policy decisions seek to shift culture and make very clear certain behaviors are unacceptable and equally unacceptable. We heard testimony yesterday that from the network that this will be watched. If it were to pass, that folks will be paying attention, and you know, if this carve out is in some way proving to be perhaps effective or what have you, maybe we would need to make a change. If we needed to make a change, and actually bring this back into the same or category as all violations of a protective order, would the existing procedures within the process in the courts suffice?
Well, theoretically, yes, because as long as the court isn't asked to do anything different, it's the same as any other violation. It's up to the prosecutor to get the evidence and bring the case in the criminal division. So assuming that it's not expected that the court's going to do any checking on it or do anything at all, it's an order, we issue it and it goes out the door. If that's the expectation, then no, it wouldn't have any impact. If there's an expectation that somehow the court's going to monitor it and the court's going to bring it back for reviews, then it would have impact. And I would imagine it may have a significant impact with respect to staffing, court time, and judges.
Okay, thank you for that clarity.
Any other questions for Judge Zone? Not seeing any. Thank you very much.
We're here just after 4 this afternoon.
We'll hear from you again this afternoon. I appreciate it.
Thank you.
So we'll now go to.
Is that
Are we
after
going-
4 or after 4?
Well, 3 of us.
Yes, do. Gary's on. Okay.
I'm there too.
Oh, right,
Yeah.
yeah, all of us.
All right. So we'll go to Gary online on Zoom. As long as you're not driving, we'll hear from you on Gary. So I appreciate it. Thank you for being. Introduce yourself for the record and proceed.
Hi, my name's Gary Marvel. I'm the Deputy Director of Field Services for the Department of Corrections, and I'm at the Bennington Rest Stop, and I'm not driving, so thanks for asking.
We're in the field. It's in the field.
All right, tell us about about your experience with my understanding, we have you here to explain a little bit about the programming that is available, that is being used currently. Or am I mistaken to know that? That's my understanding.
No, I didn't know I was going to be speaking about the program, but I certainly can. My understanding is that the individuals that would be subject to this order through this provision would be going to the same domestic violence accountability programming that folks go to when they're on supervision with us on probation, parole, or furlough. We don't oppose.
Yeah, oh, I'm sorry. Yeah, not the program itself, but how it has been working with Department of Corrections and the individuals that have been sent there that DOC is supervising. I guess that's what I should say. Yeah.
Sure. I mean, we have all the normal hiccups that you have when you have people on supervision, but as far as I'm aware, overall the programming has been going fine. We deal with individual issues with programs that come up as we do through the Domestic Violence Accountability Council. My officers will report to me or one of my colleagues if there's an issue. But overall, I'd say that we work with the programs just fine, and we've had a long-standing relationship with the majority of them. We see this as a potential intercept at an earlier junction in someone's issues with intimate partner violence.
Great. All right. Karen, this question.
Thank you for being here and for the support of this. My question is just trying to understand capacity. I think I've got the answer, but I just want to confirm as well that so DOC is funding these programs that are happening throughout the state, correct? And so wanting to confirm that funding, like you're set to maintain that, assuming we give you the funding that's needed, but and that capacity exists for paying additional folks to it.
I asked Sarah Robinson from the network about this issue yesterday, and there's been discussions with the DVAP, is my understanding, with the DVAP programs, and they feel that they can handle the numbers. I noticed that a provision was added to track this, that the network and the council would be tracking it through this bill, and I think that's wise because there's really no ways to predict how it's going to be used, as with any new option in the court's repertoire. So I think we are going to have to keep an eye on that to see if it has an impact that's going to exceed capacity. But my understanding is that they have some capacity to absorb some folks getting referred to them.
So no concerns on your end with this?
As long as we track it, and the reports I've heard that the DVAPs have been reporting that they can take in new people, it seems like we won't have an issue. So I don't have any concerns with what I've been told.
Angela.
Thanks for being here. Gary, can you share any insight you have about or regarding completion of these programs? I mean, yeah. I know it's a little different, the contexts are a little different, what we're considering as part of an RFA and your context, but can you talk about completion, successful completion, and how that communication loop?
I could get you some numbers. I don't have any numbers right now, and I wouldn't want to give you anything historical because it changes, and we've had a lot of shifts in the. For example, I don't know if the amount of completion has increased since we started funding the program for people to enter, so they don't have to pay out of their own pocket. I imagine it has, because I know that was a major issue. So we could certainly ask our data folks to see how many violations we've been filing for however period of time for people that have not completed their DVAP requirement as their conditions. But as of now, I don't have those numbers on me.
Okay.
I will say we have historically had those issues come up, from case to case, and presumably there would be somewhat less leverage, I guess, because they don't have an adjudication, and there's no underlying sentence to contend with in these circumstances.
Sure. Yeah, that's that contextual difference. I understand.
Karen.
Sorry, I thought another question came to me. So the folks that you're working with these programs are folks who are under supervision, so have been convicted of charges related to this type of programming, I guess. And so these folks would be not necessarily convicted of anything, or certainly not under supervision. Is there any concern about mixing the two populations? Or is that already happening and it's working great?
I have less concern about mixing these populations simply because of the nature of recidivism with intimate partner violence. It's very high, as I'm sure members of the committee are aware. I suspect that there'll be a fair amount of folks that have already engaged in this behavior and maybe have been on supervision if they're not currently on supervision for it. I think having them involved early on, if they're having issues with that sort of behavior, is good. I would say the DVAPs should, if at all possible within their program structure and capacity, they should try to separate folks that are scoring low risk or lower risk than the folks that are higher risk, because we know that when you mix those populations, it can be a problem. But that's going to be for the DVAP providers to decide based on what kind of groups they're running.
Thank you.
Other questions for Gary? I don't see any, so I really appreciate it. Thank you very much for your testimony. So I don't have the people. Great. I don't have the folks on the agenda, but would like to hear from Carolyn and then also Charlie on the new section 4 of the bill. I could show it to you if you haven't seen it. Carol, if you could just join us. This is the reporting requirement. Have you had a chance to see it?
I think so. It just says that we're gonna report numbers.
Yeah, I guess.
The number of people in the program.
Yeah, it's right. And can somebody hand her this is, everybody's hand, oh, wow, we're all very helpful around here. So I guess the question I had is right now, we're just saying in the 2027 report, I'm wondering if we should say that that's an ongoing requirement for the report. It's like starting into 2027.
Okay, and for your record, Carolyn Hanson from the
Thank
Attorney
you.
General's office.
Very much.
And I see that Heather Holter is also in the room, and Heather is the person that collects all this information. And she's also part of the Domestic Violence Fatality Review Commission. So we have strived to provide you with these kind of numbers in the past. And I think Heather can talk about this more, but their ability to collect data is just getting better.
Okay.
They've been working with the programs to keep track of this, and we're interested in it too. So that helps. We want to know if folks are taking this program as a result of just an RFA, or if they're there because they're under, a criminal sentence. So I think, are we good, Heather, that this is no problem for us?
And now Heather come, we'll have Heather come and join us at the witness table as well.
Okay, sorry, I didn't mean to be, but yeah,
No.
I think it looks great. The number of defendants ordered to complete a program and the number who completed the program. I mean, we'll probably break it out for you if we can, to show, who's there under a criminal sentence and who's there under an RFA. But this is easy. And we kind of already do this. I think it was in our last report. Anyway, ask Heather. But I think we put, how many people went through the program last year? And we would be happy to provide you with that as a short answer to your question.
All right, and we'll probably just have a slight change in the language saying something along the lines, and I'll work with Michelle. So it's not a one-time thing, but it's like starting with the 2027 report required that this will be reported. So it will be expected on an ongoing basis as well.
Yes.
That is clear. Okay.
And I think I said this yesterday, we don't collect any data. I just want to be clear about that. So we'd be getting this from the council, we'd be getting it from the programs. So our ability to report that to you is dependent upon their ability to do that work.
Understood.
And I borrowed this from you. Thank you.
All right, Heather, can you join us and tell us a little bit about the data collection, if this works for you as well?
Absolutely.
And we can get, somebody can give the
Like a desk copy. Heather Holzer, co-director of the Vermont Council on Domestic Violence. Thanks. So I think Carolyn said it perfectly. I think just to give you a little framework. So yes, we can absolutely do this. This language sounds great. As Carolyn said, we have been putting very basic information in the Fatality Review Commission report. So we're, we will build on this. This asks us to build on that. And we are luckily in a really wonderful situation to do that. And just sort of also kind of referring back to the questions you had for Gary. So the Council on Domestic Violence, when the shift happened to provide funding a couple of years ago to make it possible for people to access funding without paying for it, it also allowed us to invest in a database. It's a brand new opportunity for us as the council to collect data so that we no longer completely rely on the Department of Corrections data. We have our own data that comes from the DV accountability providers that is participant specific. So we can track a particular human through our database. And so we only, we're about to close, the second year of actually having 2 fiscal years worth of data about how people are progressing through the program. We've had, and Gary said it well too, we've had a lot of different changes. So what change, causes what? We are working with the University of Nebraska to, for the almost entering our 3rd year, to get some help on really looking at our data and understanding it. So that's just a long answer to your question, but just so that you understand that the Department of Corrections is one of 3 entities or pathways. And if this bill passes, there will be 4 ways for someone to get into a DV accountability program. So one of them is a self-referral. We have just under 2% of self-referrals right now. One of them is because you're under supervision by the Department of Corrections and part of your sentence requires you to engage in programming with a program that's certified by the Council on Domestic Violence. Or folks may have a DCF, Department for Children and Families case plan that requires them to participate in programming through a council certified program. So this will mean there'll be a 4th pathway. But so we are tracking all of that data and learning a lot about what's happening for people as they go through the program. And as Gary said, we are getting more and more information from the people we refer, like the Department of Corrections, which means we're getting people's scores on the DVSIR and be able to really look at who's in the room, if you will, for each program. And yeah, so that's a really long answer.
No, that's fine.
Sneaking a little bit more of the framework in there for you, if that's helpful.
That.
Okay.
So it sounds like we're good, and we just probably have a slight change just to make it clear that it's an ongoing reporting that we're expecting, with the Fatality Review Commission report being essentially the vehicle for getting us this information. So I appreciate that. Any other questions? So, okay, so I do want to just get a little discussion and you, well, I want to understand where folks are with H222. I have it scheduled for a vote after the floor. Is there anything you all need to inform your vote at this point? Or are we good? Good. Yeah, Tom? Okay, so we'll be doing that at 3:30. So we also, just some changes, and I think the agenda online hasn't quite kept up with, that's fine, Dave, it's me, not you. So we're not taking up H221. We need to do more work on that, on the language and on that particular bill before we deal with that, and we'll probably still be dealing with it probably fairly soon after the crossover. We will be taking up, on the outside chance that it's straightforward, and it probably isn't, but we have some time. So we're going to be taking up H410, which is actually currently in corrections, but it's going to be sent to us this afternoon. That's the definition of recidivism, a new definition of recidivism. And it's, we'll have today and we'll have tomorrow afternoon to work on that. If we're able to get it out, great. It is one of the components that is in the, at least I understand it is, in the omnibus public safety bill, but we kind of took it out, a separate bill that both the Senate Judiciary has and we have. And I thought Senate Judiciary was going to get to it, but they're not going to be able to get to it. And we have some time this afternoon and tomorrow. So, but we'll be here until about 5 o'clock. I was hoping to actually be late and have dinner here, but there's judicial retention. So after the floor, if you can come back, right away, we'll start 10 minutes after the floor. And that's it for now. We have time for a long lunch.